We are going to an important discussion. Take your seat. Short duration discussion. Shri Satish Chandra Mishra to initiate.
माननीय उपाध्यक्ष महोदय, मैं सबसे पहले माननीय अध्यक्ष महोदय, माननीय सभापति महोदय को धन्यवाद देता हूं और आपको भी धन्यवाद देता हूं इस बात के लिए कि आपने इस महत्वपूर्ण मुद्दे पर आपने नोटिस हमारी स्वीकार करते हुए और इसकी अर्जेंसी को देखते हुए इसको मैटर को आज टेकअप कर लिया है। इसके साथ साथ मैं अपनी पार्टी की प्रेसिडेंट, हमारी नेता, इस सदन में पार्टी की हमारी अध्यक्ष को भी धन्यवाद देना चाहता हूं कि उन्होंने इस मौके पर इस मामले में, इस महत्वपूर्ण मामले में हमको बोलने का मौका दिया, जिस विषय पर उन्होंने अपनी बात इस विषय पर पहले रखी थी और अब उसके बाद एक विस्तृत पत्र लिख करके प्रधानमंत्री, माननीय प्रधानमंत्री जी को, जो इस लीडर के इस हाउस के लीडर भी हैं, और माननीय लीडर ऑफ द ऑपोजिशन को और सभी दलों के नेताओं को एक पत्र लिखकर, व्यक्तिगत पत्र लिखकर उसमें सारे तथ्य लिखते हुए उनको इससे अवगत कराया था, उनका सहयोग की अपेक्षा की है। और उन तथ्यों को मैं आपके सामने, जो कि उस पत्र में हमारी पार्टी की राष्ट्रीय अध्यक्ष ने पहले ही रख दिया है, उनको मैं आपके सामने सदन में सभी सदस्यों के सामने रखना चाहता हूं। मानवर, जहां तक 16(4) आर्टिकल 16(4) ऑफ द कॉन्स्टिट्यूशन है, उसमें प्रोविजन ये था कि रिजर्वेशन के लिए प्रोविजन दिया गया और आर्टिकल 16(4) कॉन्स्टिट्यूशन जब से बना है तब से, इंसेप्शन से उसमें ये मौजूद है। उस आर्टिकल 16(4) के तहत में जिस कॉन्स्टिट्यूशन को डॉक्टर बाबा साहब भीमराव अंबेडकर, जिसके आर्किटेक्ट थे, उन्होंने बनाया था, बहुत सोच समझ करके उस प्रोविजन को रखा गया था कि जो लोग सदियों से इस देश में सफर कर रहे हैं इनइक्वालिटी से, और जहां सोशल बैकवर्डनेस है, जो सोशल बैकवर्डनेस ही लीड करती है इकोनॉमिक बैकवर्डनेस को और एजुकेशनल बैकवर्डनेस को, उसके तहत में उसको दूर करने के लिए और इसको बराबर करने के लिए, इस जो गैर बराबरी का चल रहा था उसको बराबर करने के लिए उन्होंने आर्टिकल 16(4) कॉन्स्टिट्यूशन में डाला था, जिससे कि रिजर्वेशन मिल सके। और रिजर्वेशन उसमें बैकवर्ड और शेड्यूल कास्ट, शेड्यूल ट्राइब्स के दोनों लोगों को दिया जा सके। उसके तहत में जब से कॉन्स्टिट्यूशन बना था तब से अनवरत रिजर्वेशन जो 16(4) में था, अपॉइंटमेंट का वर्ड जरूर यूज था, लेकिन उसके साथ में उसमें प्रमोशन में भी रिजर्वेशन दिया जा रहा था। पर इंदिरा साहनी का जजमेंट जब 16/11/1992 को आया, तो उस जजमेंट में, दिस जजमेंट वाज गिवन बाय 9 जजेस ऑफ द ऑनरेबल सुप्रीम कोर्ट। In this judgment, it was for the first time held that Article 16(4) it was being interpreted in a manner, it was interpreted that it only includes within it the appointments and initial appointment. It will not include the promotions within the ambit of 16(4), and therefore the promotions, reservation by way of promotion cannot be given under Article 16(4). But the Honorable Supreme Court also noted in this very judgment that all the previous judgments of the Supreme Court have been holding consistently that Article 16(4) includes reservation for promotion, and since this was going on, therefore once we are now holding it, this promotion, this reservation and promotion will be allowed to continue for another 5 years. During this period of 5 years, before this could be come to an end, and the reservation and promotion was continuing, by means of 77th amendment, this in the constitution, an amendment was brought which was made effective from 17th of September 1995. And under this amendment, a new article, a new provision was added into Article 16, and that was 4A. In 4A, the article, it was provided that there will be reservation in promotion also for the scheduled caste and scheduled tribes. Now, after this amendment was incorporated, before this, there was an act which was incorporated in state of Uttar Pradesh in 1994, and that was reservation for the scheduled caste, scheduled tribes and backward classes. In this, there was a provision which was 3(7), and in this, the reservation was granted in promotion also. After this amendment, the protection to that section was automatically given after the amendment of 77th amendment. Thereafter, there were certain litigations, and in those litigations, it was said that so far as 16.4 is concerned, it no doubt includes promotion by way of reservation. Accelerated reservation would not bring in accelerated seniority, and there will be no consequential seniority into this. Once these interpretations were given by certain judgments by the Supreme Court in Veerpal Singh Chauhan and Ajit Singh 2 cases, a further amendment became necessitated by the Parliament into the Constitution. And in 4A itself an amendment was done. It was provided therein that when promotion is given by way of reservation to scheduled caste and scheduled tribes, accelerated seniority would also be given to them. In this manner, the judgment which was given in Veerpal Singh Chauhan's case and Ajit Singh 2 cases, they were done away with, and by the amendment brought by the Parliament. Now, after this, there was another amendment which became necessary, because there were other judgments which came in between, and it said that the reservation in promotion, if they are not being able to be completed in the year in question for which the vacancy has arisen, then they will lapse. And as the society was going on and is in this country, that where everyone is trying to find out a method that wherever so this inequality is being sought to be finished and equality is being sought to be given by providing them reservations, so that they can also, these category of persons can also rise, and they may have the administrative control also in their hands at the higher post. Because unless there is administrative control with respect to the persons and caste concerned, it is understood that even political power, if it is there, it has to be exercised by the executive only. And therefore, keeping into this consideration, all the persons who were at the helm of the affairs in the various states, things were done that the appointments which were being by way of promotion were not being given within time, resulting that after the year they were lapsing. So to overcome this situation, the Constitution was further amended, and by means of 81st Amendment of 2000, which came into effect from 9/6/2000, another article was added to 16, and that was 16(4)(b), and by means of which it was provided that the vacancies which are not filled in a particular year, they will continue to remain alive and will be carried forward in the next year, and thereafter into the other years till they are actually filled. And this carrying forward will not disturb the 50% quota, because 50% quota, even if it is exceeding by the carrying forward, it will be the carrying forward vacancies will be filled up, because they will be treated to be vacancies of the year when they had arisen. Now, after this judgment was given, there were certain disputes again, and certain matters went again up to the Supreme Court. And it was said that Article 335 of the Constitution, it provides that the efficiency in the works has also to be kept into mind while giving reservation. And with respect to the work, efficiency has to be there under Article 335. And you cannot give any relaxation while making promotion to the scheduled caste and scheduled tribes, in spite of the accelerated reservation permitted under Article 16(4)(a). After that, a fresh amendment was brought to do away with this, so that the intention under the Constitution that these particular castes should get their right enforced through promotion by way of reservation and accelerated seniority, a fresh amendment was brought, and that is 82nd Amendment, which was effective from 8/9/2000. And under this, a proviso was added to Article 335, and which empowered the states while making the act or the rules that they can give relaxation to the scheduled caste and scheduled tribes with respect to their qualifying marks, and also for lowering the standard of evaluation while making appointment by way of promotion. So this amendment was incorporated by way of 82nd Amendment in the Constitution. Now, after this, it was thought that the matter is not settled. All these amendments have taken care of the Indira Sahni's judgment, other judgments which came from time to time, and these particular castes belonging to scheduled caste, scheduled tribes will continue to get their rights enforced of promotion by way of reservation. But in the meantime, this amendment of 77th itself was challenged again in various high courts, and the matter went to Supreme Court in M. Nagaraj's case. Ultimately,